Prior to the 1930s, investors could sue under common law for fraud, deceit, or misrepresentation, but proving these claims was difficult. Starting with Kansas in 1911, states enacted laws to regulate securities because of the very obvious need for regulation. The state laws became known as blue sky laws because these investments had no tangible assets, just lofty promises, making them as substantial as so many feet of blue sky, so basically worth nothing. However, unscrupulous promoters found a way around the state laws by selling securities across state lines. So the call for federal protections became louder, and after the 1929 stock market crash, it became clear that the existing common law and state blue sky laws were inadequate to protect investors. Congress responded with the passing of the 1933 Securities Act and the 1934 Securities Exchange Act, which completely changed the burden of proof in investor lawsuits from investor to companies and their auditors. So the key takeaway here is that statutory liability is intentional and is meant to increase transparency, hold companies accountable, and ensure that auditors take their role seriously. As I just mentioned, the 1929 stock market crash was the tipping point for stronger investor protections. It began on October 28, 1929, also known as Black Monday, when the stock market decreased by 10% in heavy trading. In the end, the stock market would decline 89% from its highest point in 1929 over the coming 3 years. Banks failed, and the Great Depression began in 1929 and ended in 1941 with the entry of the U.S. into World War II. The Securities Act of 1933, also sometimes called the Truth in Securities Act, was passed to protect investors by providing accurate financial statements and to prevent fraud, deceit, and misrepresentation. The Securities Act of 1933 focuses on the initial offering of securities. That's important to remember. This is when information asymmetry is at its highest, meaning investors often had little history to rely on except what the company communicated, while the companies, of course, knew significantly more about the financial numbers. With the passing of the 1933 Securities Act, companies had to provide a registration statement and a prospectus containing detailed financial and non-financial disclosures. These financial statements are also required to be audited by an independent CPA. If the registration statement contains material misstatements or omissions, investors who purchase the securities can bring civil claims not just against the issuer, but also against the auditors and other participants. Unlike common law claims, investors do not have to prove reliance or privity. That makes the 1933 Act especially powerful and risky for auditors. If the plaintiff can prove that damages occurred and there was misleading or false information, it is considered a prima facie case, which means that it's sufficient enough of a case, and the burden of proof shifts to the accountant. Under the Securities Act of 1933, auditor liability is broad and intentionally plaintiff-friendly. Auditors can be held liable for material misstatements such as incorrect revenue recognition and for material omissions such as failing to disclose significant litigation or liquidity problems. What makes this statute particularly risky for auditors is that liability extends to third-party investors, even those the auditor never knew or interacted with. There is no requirement for privity or near privity. In practice, this creates a near strict liability environment. While defenses do exist, auditors should assume that if a material error appears in a registration statement, they will be named in the lawsuit. And that explains why IPO audits are among the highest risk engagements for auditors. Materiality is a sort of threshold defense. Section 11 of the Securities Act of 1933 applies only when a registration statement contains a material misstatement or omission. If the information at issue is not material, then statutory liability never comes into play in the first place. So what makes a fact material? Basically, a fact is considered material if a reasonable investor would view it as important when deciding whether to buy or sell the security. The standard focuses on the investor's decision-making process, not the auditor's intent. So keep in mind that materiality is not limited to a specific number or percentage. Qualitative factors such as whether the information hides a trend, masks a failure to meet expectations, or affects compliance with contracts can make even relatively small misstatements material. From an auditor's perspective, materiality is one of the most powerful protections available because it can end the case before liability is established. If a court determines that the misstatement or omission is not material, the claim fails without ever reaching questions of auditor conduct, intent, or due diligence. However, materiality is also risky because it's often judged in hindsight by courts or juries. What an auditor considered immaterial at the time may later appear significant once other facts are known. Section 11 of the Securities Act of 1933 imposes liability for materially false or misleading statements contained in a registration statement. Historically, courts treated factual statements and statements of opinion very differently, and that distinction became increasingly important as litigation began focusing on audit opinions, which are explicitly framed as opinions rather than guarantees. The Supreme Court addressed this issue directly in Omnicare Inc. versus Laborers District Council Construction Industry Pension Fund. The central question in Omnicare was whether a statement of opinion can be considered false under Section 11 simply because it later turns out to be incorrect. The court answered no. A sincerely held opinion is not an untrue statement of material fact merely because subsequent events prove it wrong. This holding is critical for auditors. An audit report expresses an opinion that the financial statements are fairly presented in accordance with GAAP. It does not certify that the statements are perfectly accurate or immune from future restatement. Omnicare protects auditors from a liability based solely on hindsight. However, the court was equally clear in the Omnicare case that opinions are not immune from Section 11 liability. An opinion can still be actionable in three circumstances. First, if the speaker did not genuinely hold the opinion at the time it was expressed. Second, if the opinion includes embedded statements of fact that are untrue or misleading. And third, if the opinion omits material facts that would cause a reasonable investor to be misled about the basis for the opinion. For auditors, the third category is often the most dangerous. Even if the auditor honestly believed the opinion, failure to disclose key uncertainties, limitations, or contrary evidence can render the opinion misleading to an ordinary investor. This places heavy emphasis on professional judgment, documentation, and transparency. The key point of Omnicare is that Section 11 liability now focuses less on whether an opinion was ultimately correct and more on what the auditor knew, believed, and disclosed at the time the opinion was issued. Courts will examine whether a reasonable investor would have been misled about the basis for the auditor's opinion. In practice, Omnicare reinforces the importance of professional skepticism and thorough documentation. If an auditor can demonstrate that the opinion was sincerely held, reasonably supported, and appropriately disclosed, Omnicare provides meaningful protection. If not, the opinion itself can become a source of liability. Once a misstatement or omission is found to be material, Section 11 liability is triggered and the auditor is presumed liable. At that point, the focus shifts away from whether liability exists to whether the auditor should nevertheless be held responsible. And this is where the due diligence defense comes into play. The due diligence defense is the primary affirmative statutory defense available to auditors under Section 11. To successfully invoke it, auditors must demonstrate that they conducted a reasonable investigation, acted in good faith, complied with professional standards, and adequately documented their work. This defense does not deny that a material misstatement occurred. Instead, it argues that the auditors exercised appropriate care under the circumstances. It's important to emphasize that due diligence is not automatic immunity. Courts evaluate this defense critically, particularly in cases involving significant investor losses. Auditors must show that their procedures were reasonable, not perfect, and that professional skepticism was appropriately applied. Unlike materiality, which can prevent liability from arising at all, due diligence is evaluated after liability has been established. As a result, relying on due diligence often means extensive litigation, judicial scrutiny of audit work papers, and exposure to hindsight bias. For this reason, auditors generally prefer to prevail on materiality grounds rather than rely on due diligence as a fallback defense. While the 1933 Act governs initial offerings, the Securities Exchange Act of 1934 focuses on ongoing trading and reporting. This act created the Securities and Exchange Commission and established a system of continuous disclosure for public companies. Companies meeting certain size and shareholder thresholds must file periodic reports, including annual audited financial statements and quarterly reviewed statements. Auditors therefore remain exposed to statutory liability long after an IPO. The key shift here is from disclosure at a single point in time to disclosure over the life of the company. Section 10b and 10b-5 are the primary anti-fraud provisions of the federal securities laws. These rules prohibit deceptive schemes, material misstatements or omissions, and fraudulent conduct in connection with the purchase or sale of securities. Unlike Section 11, Rule 10b-5 requires scienter, meaning intent to deceive, manipulate, or defraud. This higher burden makes cases harder to prove, but potentially more damaging when successful. For auditors, the statute is most relevant when allegations involve knowing misconduct or reckless disregard for the truth. To succeed under Rule 10b-5, plaintiffs must prove 4 elements: a material misstatement or omission, reliance on that information, economic damages, and scienter. Reliance and loss causation are often difficult to establish, which is why many Rule 10b-5 cases fail. However, when a plaintiff can prove intent or recklessness, damages can be significant. Section 18 imposes liability for materially false or misleading statements made in documents filed with the SEC. Unlike Rule 10b-5, Section 18 allows auditors a good faith defense if they can show that they had no knowledge that the statement was false. However, courts have limited this defense when auditor conduct rises to the level of gross negligence. In other words, extreme carelessness can undermine claims of good faith. This reinforces the idea that professional judgment failures can erase statutory protections. To summarize, the Securities Act of 1933 imposes strict disclosure-based liability, while the Securities Exchange Act of 1934 focuses on fraud and ongoing reporting. Auditor risk increases as conduct moves from negligence toward recklessness and intent. Across all statutes, documentation, skepticism, and professional judgment are the auditor's strongest defenses. Understanding statutory liability is essential, not just for passing exams, but for practicing responsibly in the profession.